Hello, so this is going to be a quick summary of the new California laws specifically for California residential landlords. So let's get right into it. First, screening fee receipts. So under AB 1765, which takes effect now, landlords and applicants can now use email to deliver screening fee receipts. So you don't need to use hand delivery for mail. And that's about all I need to say on that one. It's not going to be very common. Trespass letters. So under SB 602, this prolongs the validity of trespass letters, also known as 602 letters, from 30 days to 12 months. And these allow property owners to alert law enforcement about uninhabited properties. This was authored by Senator Archuleta from Pico Rivera. Next, AB 12. Now, this is an important one. This now limits, in almost all cases, security deposits to 1 month's rent, except for owners of two or fewer rental properties with no more than 4 units total. Now, this doesn't take effect until July 1st, 2024. If you want more information on this, look up AB 12. This was provided by Assemblyman Haney. He's a Democrat from San Francisco. Next, micro mobility devices is another important one. So there's been a huge increase in the number of micro mobility devices such as scooters and e-bikes. Unfortunately, there's also been a large increase in the number of fires from some of these problematic batteries. So what this bill does under SB 712, which takes effect January 1st, so if you're watching this, it's already in effect, it allows tenants to store micromobility devices in their rental units with batteries approved by the Consumer Product Safety Commission or European product standards. Now, it doesn't have to be approved for that, but in order for the tenant to be able to store the unit in their unit and store their micromobility device in their apartment and charge it, it has to be tested and approved by either the CPSC or the European Product Standards Committee. So if the devices don't meet these standards, then the landlord can require the tenant to have insurance for the device, and the landlord can prohibit the tenant from plugging in that micromobility device inside the rental unit. So if the landlord provides the tenant secure long-term storage outside the unit, then the landlord can mandate that the device be stored outside the unit. This was authored by Senator Portantino, Democrat from Burbank. Next, just cause eviction. So under SB 567, this provides some amendments to the Tenant Protection Act of 2019, AB 1482, regarding just cause eviction. So these changes apply when the landlord wants to use a no-fault just cause eviction to get their tenants out. And typically what happens is the landlord moves in their family member, but what had been happening in some cases was the landlord was exploiting this loophole to get a tenant out for no fault of the tenant, claiming that they wanted to move their family in. So now they've added some additional requirements. So this applies where the owner terminates the tenancy because the owner or the owner's family wants to move into the unit, or in the cases where the owner needs to perform substantial rehab to the unit. Now, it requires specific notices, and there are penalties for property owners who violate this rule. And there are minimum duration requirements. In other words, they have to be in the unit for a certain amount of time, otherwise it's presumed to be an invalid utilization of the Tenant Protection Act's provision for owner move-in. So Costa-Hawkins and permanent disabilities. So under AB 1620, this allows tenants with permanent disabilities to maintain the same rent when moving to a comparable or smaller unit within the same building. So this provides that the following criteria must be met. First, the tenant's move is determined to be necessary to accommodate the tenant's physical disability related to mobility-related disability. Also, there's no operational elevator that serves the floor of the tenant's current unit. Next, the unit is in the same building or on the same parcel with at least 4 other units and shares the same owner. And the new dwelling or unit does not require renovation to comply with applicable requirements of the Health and Safety Code. Now, the applicable rent control board or authority determines that the the existing owner will continue to receive a fair rate of return or offers an administrative procedure ensuring a fair rate of return for the new unit. That's the final requirement. Again, that if it's under rent control or some kind of rent authority, that commission has to determine that the owner will continue to receive a fair rate of return or offers an administrative procedure ensuring a fair rate of return for that new unit. And the tenant must be current on their rent to utilize this action. So there are requirements not just for the landlord, but for the tenant as well. Now, under SB 267, this applies to credit histories and government subsidies. And this prohibits landlords from considering credit history when applicants have government rental subsidies, such as Section 8, without offering alternative means to verify rent payment. So basically, if you're getting money from the government, then you can't look at that tenant's specific credit history, because the whole point of credit history is indication of likeliness to pay. But if you're getting money from Section 8, very likely they're going to continue to pay. And then, almost lastly, increased limits for small claims. This is another important one. So now that you're watching this, because it took effect January 1st, Senate Bill 71 has raised the ceiling on small claims actions filed by individuals from $10,000 up to $12,500. So now individuals can sue for up to $12,500, or if you're a corporation, $6,250, which is obviously half of that. Now remember, before it was $10,000 for individuals, half of that, $5,000 for corporations. So it's a bump up for both. Now, there is one exception to the $12,500 cap, and that exception is that since November 1st of 2021, you can sue or be sued for COVID-19 rental debt in small claims for more than $12,500. So in conclusion, this was a recap of the new laws that are taking effect. Many have already taken effect. Some have not yet. They will later this year for 2024, specifically with an emphasis on California residential landlords. If you found this helpful, please let me know. And I would appreciate a comment. It helps me improve. It helps me decide what topics to cover next. Thank you for your time. I know it's valuable.